HR Research presents our 2014 webinar series, delivering you the latest in HR news, legislative updates, and industry trends. As a provider of leading talent screening, management, and assessment solutions, we are here to ensure your company's continued success. Global HR Research. We redefine your HR expectations.
Hi everyone, my name is Megan Schamfelter and I'm the Manager of Communications and Events here at Global HR Research. Global HR was most recently ranked as one of the top providers in the background screening space by HR Today magazine for the 4th year in a row. We attribute our success to the faith and loyalty of our clients, employees, and partners like our presenter today. We believe in better candidates, smarter hires, and incomparable customer support. I'd like to welcome everybody and thank you for joining us today for our webinar entitled End of the Year Update and Predictions for 2015, presented by Pamela Devada, partner at Seyfarth & Shaw. Ms. Devada specializes in all aspects of employment defense, including counseling, training, and litigation. Also focuses on the Fair Credit Reporting Act and state laws affecting background screening. As always, Global HR strives to provide resources to our partners, clients, and those that you are new acquaintances to us today. A follow-up survey will be sent out directly after the webinar, where you will be able to ask additional questions, make comments, or inquire about our many solutions. This will be a silent webinar today. If you have any questions during today's presentation, please feel free to type them into the questionnaire box and we will address them at the end. The entire contents of this presentation will be available on our website within 72 hours after its completion. At this time, I'd like to personally thank Ms. Devada and her team for being here today, and I'll turn this over to her.
Thanks so much, Megan, and thanks everyone for joining us today. It's hard to believe that 2014 is coming to an end. I always think of this time period and the year when I say, oh my goodness, all those goals that we tried to get done for 2014 are either slowly slipping away or we're trying to get started and wrapped up by the end of the year. So I'm thrilled to be here to talk a little bit about what's happened during the year, what we've seen in terms of hot topics over the last year in the background screening space, and then also what we think is going to come down the pike in 2015. I don't have a crystal ball. I'd love to say that I did, but I think we do have a pretty good indication of some of the things that are happening based on this last year. As Megan said, if you do have questions, please feel free to use that question or chat button, and we will be able to try and get to those at the end of the presentation. Before we get started, as Megan said, I am a labor and employment attorney, but nothing I say today is giving legal advice or counsel to anyone on the phone. This is provided for informational purposes only, regardless of if we have a client relationship or not. Certainly, to the extent that you have additional questions afterwards and want to feel free to reach out to us and or to Global HR, feel free to do that and we'll try and get your questions answered. But today we're not giving legal advice and I can't give factual circumstances. There's a picture of me, but we've already told you a little bit about myself. So before we get into, without further ado, let's go ahead and talk a little bit about what we have seen in 2014 and what we believe that we're going to see in 2015. And let me start by saying we have seen a huge increase in the amount of litigation that has happened in the world of Fair Credit Reporting Act. We've also seen some huge increases in terms of regulatory enforcement, as well as some new legislation and some potential new guidance. So why don't we start with the first thing, which is there have been additional states that have put forward credit reporting restrictions. For those of you who on the phone and on the webinar who are running credit checks, please understand that these have been under scrutiny. They've been under scrutiny very similar to criminal background checks for the exact same reason, specifically that the EEOC and certain consumer groups believe that this tool, credit checks and criminal history, potentially has a disparate impact on specific minority groups, African American individuals, men, and Hispanic individuals. And therefore, it's very imperative for you to know that there are state laws that regulate this, and frankly, there are some new potential credit history guidance that may come out from the EEOC. currently there's 10 specific states that prohibit the use of credit histories. And we saw one of these just go into effect, actually a couple of these go into effect at the beginning of this year. I would say that the momentum for credit history regulation and legislation, which is what we're talking about here, has slowed down a little bit. You'll notice that in 2013, there were 47 bills that were pending, and in about 26 different states. There's some that are having some critical mass. So, for example, you'll see that there's a couple of other states that we think might be passed in 2015. So the takeaway really for this piece, and we don't want to belabor it, is number one, make sure that if you are running credit, that you are aware that there are state laws that specifically prohibit or restrict the use of credit in some states. So make sure that you are in one of those exceptions. For example, money handling or fiduciary or law enforcement or a managerial position. That's an overview. So you need to make sure that the specific state has a specific exception while you're running the check. And also make sure that you understand that there are specific notices that must be given. So for example, in California, if you are going to run a credit check, you actually have to tell the individual the specific reason and the specific enumerated reason under the statute that you're going to be taking action or running a credit check. So understand that. The other thing to just notice is that the EEOC is very, very concerned with the issue of credit. And I think that we may be seeing some guidance back in 2012 when the EEOC criminal history guidance came out, which we're going to talk about next. What we did see was we thought that there was going to be credit guidance. Now, that wouldn't be a statute, it wouldn't be a regulation, it would be similar to the EEOC criminal history guidance. The former chair of the EEOC, Jackie Berrien, is now no longer the chair. She has moved on from the EEOC. One of her biggest goals and charges was to get criminal history guidance. The new chair is Commissioner Jennifer Yang. She is a former plaintiff's counsel, so it remains to be seen what her agenda items and hot topics are going to be. We haven't seen much in terms from her that she's really focused on the area of credit, but we have heard rumblings from the agency that perhaps that is a guidance that they might tackle in 2015. As we all know, and I will go very briefly over this because Global HR has done a great job of doing other webinars and presenting information on the EEOC criminal history guidance in the past. But the EEOC criminal history guidance, I think what happened in 2014 was we saw more individuals really, more individual companies really paying attention to this guidance. We saw a number of EEOC charges being brought and filed specifically about the EEOC criminal history guidance and more importantly about an employer's use of criminal history guidance. So wanted to understand that and make sure that you understand that if you have not, as an employer, taken action to potentially remove a criminal history question from your application or consider what you are allowed to ask in terms of criminal history or how you are evaluating and using criminal history in employment, you really need to make sure that you get educated on that. Now, because it has been 2.5, almost 3 years. In April, it will be 3 years. Certainly, the EEOC and plaintiffs' counsels are going to say, employers, you've had enough time to implement this. And there's going to be, I believe, in 2015, an increase in the amount of litigation. In 2014, we saw an increase in litigation specifically from the EEOC on some of these issues. The BMW case and the Dollar General case are disparate impact claims where the EEOC is specifically alleging that there is racial discrimination based on a policy that BMW had and Dollar General had, excluding individuals with certain criminal history based on the fact that they didn't follow the 2012 guidance. Both of those cases are pending. There are a number of different theories going back and forth with those cases. Just as a quick overview, EEOC versus BMW is a case out of South Carolina where basically a staffing company was involved, and the argument or the issue there was the staffing company had not been complying with or applying BMW staffing criteria. And so people had been working at BMW for many, many years, dozens of years. And then a new staffing company came in, and all those employees were moved over to the new staffing company, and the new staffing company began applying the criteria that BMW had on the books for many, many years. And what happened was there were 69 individuals that actually were terminated, even though they had worked at BMW on the BMW plant for many, many years. The EEOC is very focused on new policies or employers who are being bought, have a new policy, have some sort of acquisition that the person, had a conviction, for example, 5 years ago, but has been working for you for 3 years. How does that affect their ability to perform the job? Same thing with Dollar General. The focus in that case really deals with matrices, having either bright line rules or matrices that's a one-size-fits-all, a hiring criteria. Be very careful about doing that. EEOC versus Freeman and EEOC versus Kaplan Higher Education, what we saw was, frankly, the end of those cases. And so those cases are big cases where the EEOC, again, alleged disparate impact, one on the basis of credit and criminal in Freeman and one on the basis of Kaplan. They lost those cases. They were appealed, and so those were very big losses for the EEOC. They then brought the first two cases, BMW and Dollar General. So what we think that we're going to see is really a trend in an increase in this litigation. It may be a little slow going at the beginning of the year. Part of this really is going to depend on what happens in the BMW case, what happens in the Dollar General case. One thing that the defendants are trying to do in both of those cases is get information about the EEOC's practices. We were able to do that in the Kaplan Higher Education case, which was a case that myself and my partners defended. And what was very interesting about that is that we were able to find out what the EEOC did with regard to credit checks, and that was admissible. Unfortunately, they're having a war in the BMW case right now about who gets what information, and so far the EEOC has been winning in terms of not having to provide information about their own practices. Remains to be seen, but we're very much watching this case and going very closely on that case as well, on both of those cases. Another area that we're seeing really a hot topic in, and this is where we've seen really the increased litigation from the private plaintiffs bar. We talked about the EEOC litigation. We are now looking on the issue of private plaintiff litigation, both on a single plaintiff basis as well as on a class action basis. And the reason that we're seeing this and what we're really seeing is that these cases are easy to bring. They are cookie cutter oftentimes. They're cut and paste complaints, and they're focused on specifically employers. There's a whole other group of cases that is focused also on consumer reporting agencies. But just as a recap, remember, you as an employer have 4 specific responsibilities under the Fair Credit Reporting Act. One, you have to have a permissible purpose for getting the report. If you have an employment purpose, you have to provide the person with a disclosure consisting solely of the disclosure. If you have an employment purpose, you have to take a 2-step adverse action process. And then finally, you have to give a certification to the background screening company that says specifically you're going to follow those things and you're not going to violate the EEO laws. Well, the main challenges we see are to the specific disclosure and authorization form that you're using. And I say here is the FCRA, the next FLSA. For those of you who are employers, you know that wage and hour cases are at a huge increase and have been for many years. They're easy to bring, and they are, again, often very, very large classes of individuals. We have seen an enormous increase in the amount of FCRA cases against employers. Indeed, we track these, and just this week alone, it's only Wednesday, and I've seen 8 new cases that have been filed just this week against employers alleging the specific theory that we're going to talk about here. So the law says if you are an employer, before you can request a background check, that you must provide a consumer, an applicant or an employee, with a form that discusses that what and discloses what information you're going to be running about them and why. It has to be a standalone document consisting solely of the disclosure. The problem is that the statute in the next sentence then says that that disclosure can actually be part and parcel of the authorization also. You also have to get a written authorization. And for many, many years, most companies have a one form that says disclosure and authorization, and they're putting it together. And that absolutely is going to be allowable under the law based on the plain language of the statute. The problem is we're seeing many, many, many lawsuits that are attacking the veracity of that form. And they're attacking it in 3 or 4 different ways. Number one is the release of liability. There's about now 8 or 9 cases that have been decided on this issue. And basically it says if you have a line in your disclosure and or in your combined disclosure and authorization that says, I hereby release from liability anybody who provides information and or the employer and or my background screening company from providing this information. There has been a series of cases, Reardon versus Closet Maid, Singleton versus Domino's, that have held that that makes that disclosure violative. That's a problem. There have been other cases, however, a case in California against a company called MI, a case called Waverly Partners, Smith versus Waverly Partners, that have held that that release of liability doesn't necessarily mean that that disclosure is violative. But it's picking up critical mass. So be very clear that you review your disclosure and authorization forms and consider, number one, consider separating the disclosure from the authorization, but also consider, and I would do more than consider, but remove any release of liability language that you have in there so as not to be the next class action unless you really want to fight that. Not saying it's not defensible, but please do understand that there's a lot of litigation on that, and it's happening more every day. Another challenge to disclosure and authorization forms is state law information. I think this is it's frustrating because in order to comply with the state law, somehow saying that that's violating the federal law, I think that that is a silly argument, but indeed it is an argument that is being made, and so you want to make sure that you at least remove the state law information or consider putting it on a separate page or putting it with the authorization or doing something so that you can have the argument that you don't have this quote-unquote extraneous information on your disclosure and authorization. There's arguments that people are not providing the summary of rights. Let me be very clear. You only have to provide a summary of rights with the disclosure and authorization form when you do an investigative consumer report. An investigative consumer report is when you deal with interviews. So, for example, when Global HR would do interviews of individuals. What happens, though, is sometimes an employment verification can become an investigative consumer report. And then finally, if you do separate your disclosure and authorization, we're seeing challenges where people are forgetting, and so they separate these forms, but their well-intentioned HR or recruiting team has separated, for example, the disclosure and authorization, but then only gives one of the forms. You have to provide both forms. So what are some best practices? Please make sure that you get your forms reviewed. Make sure that you get them reviewed by your counsel. It is absolutely only your responsibility to make sure that these forms are accurate and that are going to be keeping in line with the ever-changing law. Consider separating the forms from one another. Consider putting the state law information on a separate form. Timing, I say this because class actions can only be brought if you run a certain number of background checks and or a certain number of people sign the disclosure. And so one argument is to move that part of your process, instead of every applicant that applies, to move that later into the hiring process, because it's going to reduce the number of people that actually see the form and sign the form. If, for example, you only ask the people whom you've given a conditional offer of employment to. You don't have to do that, but it certainly could mitigate your risk. Similarly, we see, we're going to talk about ban the box, but what I'm talking about here is the criminal question from the disclosure form. That's going to be deemed extraneous information, possibly. So please consider taking off the criminal history question, not from the process, but from that specific disclosure form. All right, in addition to the disclosure and authorization, huge amount of increased litigation, the other thing that we're seeing against employers are an increased amount of litigation with regard to ban the box laws and adverse action. So remember I told you that there are 4 different responsibilities under the Fair Credit Reporting Act. What we are seeing is that in employment, as everyone should know, if you are going to take action in whole or in part based on something in the report, you have to follow a very detailed, specific 2-step adverse action process. For every other permissible purpose under the law, you have to just follow a 1-step. But for employment, you're going to need to follow a 2-step. And the FTC has certainly deemed that other than traditional employment relationships, volunteers, for example, temporary staffing workers, independent contractors, in their opinion, all fit under that employment rubric. So understand it may be a little broader than what you might think, so you should get advice of counsel on that. An overview of the 2-step process that you should all know is that before you take action, just as a reminder, you need to provide a copy of a letter or document that says that the person that you're thinking about potentially taking adverse action on the person. Remember and be clear that there are some state law nuances. You have to provide a copy of the report everywhere under the federal law. You have to provide a copy of the summary of rights that has been published by the CFPB, and you have to wait. And the FTC has held that a reasonable period of time to wait is 5 business days. New Jersey, Washington, Massachusetts, and New York also have very specific state requirements that you must deal with if you are reporting information on an individual who may be living or working in that state. You also need to be careful because with some new ban the box laws, there are new timing requirements for certain states. For example, Newark, New Jersey requires 10 days instead of 5 days for the waiting period, 5 business days under the federal law. You've got a couple of other states that have very specific requirements like, DC and San Francisco that we're going to talk about. Then and only then can you send out the adverse action letter. So what are we seeing and why does this, this is not new. This is not a hot topic necessarily, but it really is, and here's the reason why. Because although this law has been around for a long period of time, what we have been seeing is, and I call this the no good deed goes unpunished, is new types of claims against employers who fail to follow the specific, very strict letter of the law. So for example, a recruiter, very well-meaning, gets a background check on a Friday afternoon, and the person is supposed to start on Monday or start orientation on Monday. Very well-intentioned calls the person and says, there's a problem with your background check, you can't start Monday. Well, that potentially, or at least has been alleged in litigation, is adverse action. Because what the consumer hears is that they have lost a job, even though we may just be moving back orientation. The better practice, number one, is not to have a start date before you're going to get that background check back so that you can have the waiting period. And that you can have the process of giving the letter, waiting, and then giving the adverse action letter. It's also going to be very hard for a recruiter to remember what they said to a specific person 2 years down the road after litigation has ensued when they've seen thousands and thousands of individuals. The other thing we're seeing is a failure to provide the waiting period. So, for example, combining the adverse action and pre-adverse action letters together. You cannot do that. Or failing to have a reasonable period of time. Now, the FTC says you have to wait a reasonable period of time. They've opined 5 business days. Is that the end-all, be-all? Well, certainly you could argue that there is additional time that was warranted. Or, for example, if the person admits everything, that maybe less time was warranted. However, you really need to take a look at that and understand. The other thing that we have seen is with adverse action is, how the person is getting the information in terms of timing. If the person is going to be getting this document via email or electronically, you want to make sure that you have complied with the e-sign requirements. There's a requirement in e-sign under the federal law that says that for those states who are not governed by UETA, the Uniform Electronic Transactions Act, and there's only 3 of them, it's New York, Washington, and Illinois, that if you're going to be sending something electronically, that you might want to, or you might need to, get their consent to do so before sending out a notice. If you don't have a centralized process, so for example, you've got recruiters, you've got 20 different locations, and you've got recruiters all over the place, they may not be sending timely notices, or you might think that your background screening company is sending it for you, but you don't know and you haven't confirmed, or you don't check the system. And so, for example, somebody decides to call up someone assuming that the adverse action timing has happened, but it hasn't. That's one reason why having a centralized process is tremendously important, and we would certainly highly recommend that as well. And then again, failure to provide the state law notices. And we've seen now some litigation, we've seen some charges on this. There are a number of states that have very specific details. So for example, Newark, New Jersey has a 10-day waiting period. Both Washington, D.C. and San Francisco require that you specify why you're taking action. So for example, is it based on the criminal history or on one specific conviction, or is it based on an employment history? What is it based on? And then there's other state law notices, so you really need to make sure that you stay abreast of the ever-changing. And what we're seeing is that these changes aren't coming across in the federal law, right? They're coming across in issues like these ban-the-box laws. So that's when it becomes a big problem that you really want to make sure that you're staying on top of. Another thing that we're seeing in terms of more litigation and some trends in 2014 is that wonderful tools like, for example, applicant tracking systems that can really be helpful can make you run afoul of the Fair Credit Reporting Act. And what I mean by this is sometimes the people who are in charge of the applicant tracking systems are not necessarily the same people who are in charge of, for example, the background screening process. And so you've got a wonderful applicant tracking system that may not comply with certain things, like, remember we talked about the disclosure and authorization forms. If you've got a tracking system where you house disclosure forms, for example, and it's part of the application and there's no separate delineation, you could be ripe for a lawsuit. You want to make sure that it's either on a separate web page or that it is on a scroll box that's separate and apart. You want to make sure that similarly that disclosure doesn't have extraneous information on it that we talked about before, regardless of if these disclosure forms are paper form or if they are in electronic form. It still applies the same. So you want to make sure that you're aware of that. The next one is the next bullet point is one that we see, unfortunately, all too often. And this, again, is the no good deed goes unpunished, which is the issue of auto-generated rejection letters. So oftentimes what you'll see is that the concern is in an applicant tracking system, they've got wonderful, wonderful tools that allow you to disposition someone when they don't move to the next section. So you have a candidate, you move that person to the next section, but perhaps you decided to not move everyone else. And everyone else gets an automated email that says, thank you so much, we decided to go with another candidate, for example. I call that an auto-generated rejection letter. Those are great. They're not great when you are taking action against someone in whole or in part based on the background check, because that is basically you are telling the person that they haven't gotten the job before the pre-adverse and the waiting period and the adverse action. We've had 4 different class actions on this specific basis. And it's certainly not done with malice, but what happens is the people that set up the applicant tracking system don't know that they need to turn off these auto letters, and they never even know that they're going out oftentimes. So you want to make sure that whoever is in charge of your background screening process today, we need to make sure that you are setting those up, making sure you're turning off auto generation, and also making sure you understand the integration. If you've got an integration with Global HR, for example, understanding who's doing what when, so that you don't fall into this trap, if you will, of letters being sent out without that pre-adverse action letter. We see that all the time. And we also see, so as a tip, make sure that you have disposition codes in your applicant tracking system that are going to be helpful. For example, one for falsification is always helpful. One for background check issue is helpful, so that those letters, for example, are coded so that they don't go out when you code that person in a certain way for a disposition code in an applicant tracking system. And train your folks, train the recruiters, train HR, train the people who are going to be managing the applicant tracking system or dealing with that system about these issues, so that they can help issue spot and ensure that these things are not happening. And then finally, the state law forms and documents. There's a variety of different states that you're probably aware of that have requirements. So for example, Minnesota, Oklahoma, California have requirements on the disclosure form. For a checkbox, you've got issues with regard to the New York Article 23A of the corrections law that needs to be provided, and many other things. And if the applicant tracking system doesn't know that, it's going to be a problem, and can put you up for a lot of liability. Speaking of liability, just as a reminder, why are some of these hot topics so important, and why do you care? Certainly, I would tell you that there are, number one, an enormous increase in the amount of litigation that we have seen. But the damages are tremendously, tremendously high lately. And here's the reason why. Under the Fair Credit Reporting Act, there are two types of claims that a plaintiff can bring. And they can bring it on behalf of themselves, or they can bring it on behalf of a class, as we talked about. And there are different rules that they have to follow and that they have to prove up to bring a class action. There's a negligent noncompliance claim, and there's a willful noncompliance claim. We are not seeing very many negligent noncompliance claims recently, and the reason being is because those claims are generally not able to be brought on a class basis, because the damages are done on an individual basis and are calculated on an individual basis. And so as a defense counsel, I can come in and basically say, I'm going to fracture that class. The individual issues of each person predominate over the class issues that are akin to everybody in the class. They're unique, and so therefore we don't see a lot of negligent noncompliance. Negligence just means you had a duty and you made a mistake. The damages under a negligence theory are actual damages, sometimes compensatory damages, which means emotional distress usually, and attorney's fees. But there's no punitive damages under a negligent noncompliance case. There is under a willful noncompliance allegation. A willful noncompliance allegation, the plaintiff has to prove that you acted with malice and or reckless disregard for the law. It's a very high burden. There is a case in the FCRA space. There's a case called Safeco, which specifically talks about a Supreme Court case that specifically talks about how high the burden is and what you're going to have to prove as a plaintiff's counsel. This is one of the biggest gifts that we have as an employer and as a CRA to argue we weren't acting with malice or reckless disregard. But the more lawsuits there are, the more the plaintiff's counsels are able to say, you should have known better and you should have taken action and you didn't, and therefore you were acting with malice or reckless disregard. The key is for a willful noncompliance claim, the person can get either actual or statutory damages. And statutory damages are either somewhere between $100 to $1,000 a person. People always ask me, what does it depend on? And there's really not much guidance. It depends on, frankly, how much the plaintiff's counsel is willing to settle for oftentimes, or what a jury would hold is going to be reasonable. And so the issue there is that you have these statutory damages, and so now class certification is much easier to get because it is not an individualized assessment of damages. It is everybody has the same damages. You're also allowed to seek attorney fees, and then here's the kicker: punitive damages. And the problem with that is that punitive damages are often very, very high. And so you want to really be careful about that. And I mentioned the statute of limitations because if you are sitting here thinking, this isn't that big of a deal and there's not that much exposure, think of it this way. The statute of limitations is either the earlier of 2 years from the person that the person knew or should have known or discovered that there was a violation, or 5 years from the date of the report. And what I mean by that is that your exposure or potential exposure would be take the amount of background checks that you have run in the last 5 years, for example, multiply that by $1,000, and that could be your statutory damages for a willful noncompliance claim. That's not even adding attorney fees, which we all know are extremely expensive, and the addition of punitive damages. So understand that these claims are very, very expensive. You want to make sure that you understand the risks because we are seeing more and more and more of these claims. And we're not even seeing them brought by just one or two plaintiffs' counsels. We're seeing an entire consortium of plaintiffs' counsels who are bringing these types of claims, and they're teaming up together. We normally see somewhere between 4 or 5 different plaintiffs' counsels on one complaint. And so you really do want to be careful of that so that you understand what your risk is going to be. Let's change topics now and talk a little bit about our last topic, Ban the Box, and then we'll get into some of the trends for 2015. And I think the issue is from the perspective of Ban the Box, while we haven't seen that much litigation, we have seen an awful lot of new impetus of legislation being passed. So for those of you who are keeping track, even in this year, we've got Illinois and New Jersey and the District of Columbia that all were passed in 2014. Illinois goes into effect January 1st. New Jersey goes into effect March of 2015, and the District of Columbia is already in effect. Many of the Ban the Box, as a refresher, Ban the Box just means when or if you are allowed to ask about criminal history on an application, generally speaking. And so some of these Ban the Box have very specific nuances of the fact that you can't ask until conditional offer. There's only 3 states, and you'll see on the slide, it's Baltimore, Maryland, Hawaii, and Washington, D.C. Others say you can't ask until a time of an interview, for example. Still others say you can't ask until a person is told that they're going to be eligible for an interview, like Illinois. The concern here is that these laws are happening all the time. You'll look, there's also not just state laws, there's local ordinances. So the local ordinances are listed there. You've got Philadelphia, you've got Buffalo and Rochester, New York, Seattle, Washington, Newark, New Jersey, Baltimore, Maryland, San Francisco, California, and Montgomery County, Maryland is the one that just passed. It's been about a week now. So just in 2014, we've had about 5 or 6 different laws that have been, and these are for private employers. If you are a public employer, understand that there will be more laws that apply to you. And so you do really want to make sure that you understand what those are and what those say. I will tell you some other information with regard to this Ban the Box. The EEOC is still looking at this issue, right? Their guidance says that you shouldn't ask about criminal history because it is a barrier to employment. So you really want to make sure if you're a nationwide employer, or frankly, if you're in any jurisdiction, that you understand what the laws are. I will tell you that New Jersey and Newark, New Jersey, there's a little bit here of a nuance, which is while the Newark, New Jersey law is still in force and effect, it may be preempted by the New Jersey statute. So it remains to be seen, but right now it's still in force and effect. So if you have more than 5 employees in the city of New Jersey, you're going to have to follow that law. As of March of 2015, that may be preempted by the New Jersey law. We have heard rumblings, though, that that the mayor may sign, for example, an additional law. So there you go in terms of the ban the box. The takeaway is review your applications, very strongly consider removing criminal history from the application itself, and make sure that you stay abreast of these new laws because they are really changing all of the time. So what is on the lookout for 2015? I think, frankly, very much of what we have seen in 2014 with a couple of caveats. So first of all, you now have 2 government agencies that have jurisdiction over the Fair Credit Reporting Act, the Federal Trade Commission and the Consumer Financial Protection Bureau. The Consumer Financial Protection Bureau has been investigating and has been looking at consumer practices in this area since its inception. We're seeing an increase in the amount of investigations that they're doing and the investigative demands that they're sending out, both against employers as well as consumer reporting agencies. There may be an amendment to the Fair Credit Reporting Act. There have been 4. There may be another. We believe that may come. There's one pending with regard to credit history. So I don't think it's going to go anywhere. It certainly is not in this lame duck Congress, but we do think that the regulatory agencies are absolutely going to play more of a role in the next year or so. The other thing that we see is the potential guidance we talked about from the EEOC. We may see more discussion about credit. Let me just back up real quick to the FTC. The FTC actually just published a guide, an employer guide, about the Fair Credit Reporting Act and background checks. So we see these educational materials coming out. I think it's their way to say, look, we've shown you, and if you continue to not abide by the law, then you do so at your own risk. If you haven't read that, take a look at that. I believe it's on the CFPB's website and the FTC's website. Continued focus by both states and localities of ban the box. This isn't going anywhere. I think we're absolutely going to see a huge increase in this. And so you really want to make sure that we are keeping abreast of this. And if you are going to keep it on your application, understand that your application is going to have to be changing, which is why most companies that we deal with have chosen not to keep that ban the box information on their application itself. And again, the FCRA litigation, it's not going anywhere. This is a huge moneymaker for plaintiffs' counsel. Hardly any of these cases go to trial, or they either get dismissed on a motion to dismiss or dismissed with summary judgment, or they get settled. And frankly, the majority of them get settled. There are smart plaintiffs' counsels out there that are doing the gotcha moment for many employers. And if you find yourself with a class action, you want to make sure that you understand what it is and how, what your potential exposure is, and make sure you get counsel who really knows this area, because certainly the plaintiffs' counsels now in this area are getting up to speed very, very quickly. The other thing I would tell you is with regard to the EEOC is that they are certainly having many more charges and a ton more of litigation. I would, they had some big losses, and if BMW and Dollar General don't go the way they want, believe you me, I think that they are going to be looking for more test cases. I think they're already looking for more test cases in the agency level. There's a lot of cases that have been pending for a long time. They're looking for that one that they can take all the way, because their theory is that the use of credit and the use of criminal history has a disparate impact, and they want to be able to show that. So far, with some sloppy lawyering, they haven't been able to show that. And so they very much are wedded to the idea that their theory is solid and based in foundation, and therefore they want to be able to prove that. So what that means is more to come. You may be the target. If you have an individual you are looking at their criminal history or credit, please make sure to consider the EEOC criminal history guidance and to consider the 3 green factors and the individualized assessment that they ask you to take into consideration. If you don't have a background screening policy, consider having that and implementing that so that you can be ahead of the curve. And with that, I'm going to go ahead. We've got about 15 minutes left, and we wanted to make sure that we had time for questions. I'm going to open it up for questions. I see we have a couple. Just as a reminder, this webinar is being recorded, and you will have access to the slides. This is going to be on a Global HR is going to provide these to you, but understand that it will be for clients and prospects only, and people who are on the webinar. It won't be made public. But if you do have questions, I'm going to ask you to go ahead and ask those now, and I'm going to turn it over to the folks at Global HR.
Hey, Pam, we have a few questions for you to answer, actually. One is, should the pre-adverse action letter be sent before or after they talk to the applicant about the report?
Great question. And the answer is, the law doesn't say, but the best practice in what I like to do is to give the person the letter so that they actually have the report in front of them when you're talking to them, so that it's very clear that they know what they're talking about and nothing is hidden. The other thing is, if you talk to the person first, then you have to give the pre-adverse action letter, and then if they call back, you have to have another conversation with them, and so it slows down the process. It actually streamlines the process if you can provide them the pre-adverse, the summary of rights, and the consumer report before you speak to them.
Okay, and then kind of going off that question, there's another one asking, is there a minimum required or recommended waiting period between the pre-adverse and adverse action letters?
Yes, and the law says a reasonable period of time. The Federal Trade Commission has said 5 business days.
Gotcha. Any other questions, anybody? Feel free to type them in the box. We'll wait on the line for about 5 more minutes. Unless there's no questions, then we'll end the webinar. So just type them on in if you have them.
And I just can't stress the training of your staff. It really is tremendously important.
Well, thank you, Pam, very much for today's webinar. It looks like everybody's kind of logging off, so we're going to end up ending the webinar. Thanks, guys, for joining, and have a great one.